All right, everybody. Thank you for joining us. This session focuses on Title IX and is pretty much kind of Title IX 101, an introduction, if you will, to kind of assist you guys with your esports programs. We're very, very fortunate to have Jason Montgomery with us here today. He represents Hush Blackwell, and Title IX is just every day what Jason does and what he focuses on. So Jason, I'm going to kind of let you take it away with the presentation. After the presentation, I'll be sure to kind of facilitate questions from the audience. And then also if any folks have questions in the Zoom chat, I will pull that up after the presentation as well. So I'm going to kick it to you, Jason.
Thanks a lot, and good to be joining everyone and talking about Title IX. Just, real briefly, I'm a partner at a law firm called Hush Blackwell, and we have a large higher education practice. As part of that higher education practice, we deal with Title IX issues. My specific expertise is related to collegiate sports, Title IX, and equity issues. And so I'm going to give a little 101 on both equity issues and sexual harassment issues, and then open the floor up to some discussion and questions from the group related to Title IX and your experience that you all have had institutionally and what questions you may have. So let me start off, and what we're really going to talk about first is the application of Title IX to esports and how that may look. We're also going to discuss equity in athletics and sexual harassment. And those are two components of Title IX that I think everyone is familiar with in some respects. Just as a baseline understanding, everything that has come out of Title IX is down to this, one section of the 1972 Education Amendments. So Title IX is actually the 9th Amendment of the Education Amendments of 1972, and very clearly states that no person in the United States shall, on the basis of sex, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any education program or activity receiving federal financial assistance. So the hook here for all colleges and universities is the federal loan program and the federal assistance that the government provides. And the enforcement mechanism is twofold. One, it's the U.S. Department of Education's Office of Civil Rights Unit that investigates potential Title IX violations. And independent private lawsuits that can be brought under this section. And when we're talking about the athletics context, we're really talking about two primary areas: equity in athletics and sexual harassment, and focus on handling Title IX sexual harassment cases in particular. With respect to equity in athletics, the first question, we list three factors here. These are the three areas that institutions need to be in compliance in order to be fully compliant with Title IX. You need to have equity and participation of male and female students with respect to the student population. You need to have equity in any financial aid that's provided to male and female student athletes for athletics. And you need to have equity in treatment. And we'll talk about each of those areas briefly. But first, kind of a preliminary question I think that's out there is, does Title IX equity apply to esports? And I'm frankly, there's not a good answer. The answer is maybe. I do believe that in the context of NACE, that creates an infrastructure that is more like a collegiate sports environment than any other, such that there's intercollegiate competition, and that the OCR could determine that an esport at a particular institution is subject to an equity evaluation. What is going to happen is this is going to be a case-by-case analysis. The OCR has not commented as to whether esports in particular fit the definition of a sport, but it has given some guidance in the 2008, what the department calls a Dear Colleague letter, where it provides information to institutions about how to apply the law. And in that Dear Colleague letter, they said, we're going to look at each particular sport on a case-by-case basis, and we're going to evaluate whether there's a governing body associated with it, so check that box, whether there's structure and administration and what that structure and administration look like, and whether there's team preparation and competition. And the Dear Cogley letter sets out different factors as to how they're going to analyze that. But they're going to do that on a case-by-case basis. And so that leaves institutions, especially with well-developed esports programs, in a bit of a purgatory, so to speak, when it comes to whether we need to be concerned about equity in athletics considerations. What I guess, kind of what I would say generally is, if it walks like a duck, if it quacks like a duck, it's probably a duck. So if your esports program gives scholarships, you're incorporated with your athletics program, you compete against other institutions as part of a national governing body, those are all factors that are going to go towards the OCR in particular, determining that this is a sport that needs to have equity considerations. And so why is that really important? It's because that in order to be compliant with equity in athletics, you have to meet certain factors. And the first is equitable participation. So the concern would be in esports in particular, that there are more male participants potentially than female participants, and that could throw off a proportionality analysis or even a financial aid analysis. But let's talk about each of how this is going to be analyzed for purposes of Title IX. First, equitable participation. In order to meet this prong of the Title IX requirements for equity, you need to meet one of these three factors. So you need to either show that your sports program is substantially proportionate, meaning that you have male and female athletes competing in intercollegiate athletics that are recognized by the OCR in equal proportion to your student population for male and female students. And so it's done on a institutional basis, and it's institution by institution. That's one way to meet the requirement. And basically the OCR has said you need to be within 1%, greater than or equal to 1% in order to meet this requirement. There have been court cases that said, as much as a 3% difference in proportionality is substantial proportionality. But the OCR is at the 1% threshold. So that's one prong. Another way to meet equitable participation prong is history and continuing practice of program expansion. This usually involves adding programs, adding female sports in particular, and demonstrates that the institution is making efforts towards gender equity in intercollegiate athletic participation. And that's usually a bridge and has not been relied upon by institutions to a significant degree in order to meet the participation problem. And so really, and that's because the adding of sports is so significant for an institution that oftentimes is difficult to demonstrate a continued history after a time period that has met the need. And then the final way to meet equitable participation is fully and effectively accommodating the interests and abilities of the underrepresented gender. And that's typically, obviously, women. And the way you have to go about doing this is you have to survey your student population, document the activities that those individuals are engaged in, and determine that the activities that are being provided in an intercollegiate manner are consistent with the interests of your student population. So this requires some significant work on the institution's part on a continual basis in order to utilize that factor to meet equitable participation. I will say that a lot of institutions try to rely on C here to meet the equitable participation prong, and they do that by sending out annual surveys to their student population. I do think that you all may do that on your campuses, I'm not sure, but it's certainly one way that institutions can document for the OCR that they are taking equitable participation seriously. Equitable financial support, again, requires substantial proportionality. You know, you're going to hear that term over and over again. What does that mean? Again, greater than or equal to 1%. Here, instead of measuring against the student body, we're measuring against the athletes that are competing in intercollegiate athletics, male and female, and how much athletics assistance each population is receiving. And so the proportion between those, how many athletes are competing versus how many athletic scholarships are provided, needs to be within 1%. So greater than or equal to. And that's a pretty straightforward calculation. The last area, which we'll talk a little bit more broadly about, is equitable treatment. And equitable treatment sometimes is called a laundry list of activities. It's about, I think, 12 or 13 different activities that are identified by the Office of Civil Rights that they will evaluate to determine independently whether the, for example, locker rooms. Are the locker rooms provided equally? Is academic assistance provided equally? They will evaluate each of these areas for the totality of every male and female program. And it's a fairly subjective area for sure. And so I put down here, one thing to ask if you go back and ask is, has your institution had an outside review related to equity in athletics? And does the institution consider their esports program to be part of that process? And if so, how are we accounting for what we're doing within that program to ensure that in a mixed gender type of environment, that we are meeting our requirements for equity in athletics. So again, the treatment areas, I've listed them out. These are taken straight from the Code of Federal Regulations, which is what is, the adoption of the Title IX requirements for institutions. So you can see some of these fit squarely with what you do in esports. Some of them not so much, because really this contemplated what I think was traditionally deemed to be intercollegiate athletics. But as that has evolved, these regulations don't necessarily evolve with them. The thing that I will note is there's an other to all of this. So the Office of Civil Rights can always identify other areas they think are important to evaluate in terms of treatment. The other big point here is if the OCR came in and did a review of your campus and included esports in this evaluation, they're doing a review of the totality of the treatment of all athletes, not treatment in a particular sport. So if there's a deficiency in one area of the athletics department with respect to treatment, let's take, for example, a locker room situation that hasn't been updated in some time, that can be made up in other areas if there's equity in other areas that outweigh one treatment area not being compliant. There's also the ability to determine that the reason for inequitable treatment is the basis, there's a non-discriminatory rationale for that treatment. Typically, you can think of like coaches' compensation, market value being a non-discriminatory reason for differentiations in coaches' contracts at the highest level. But non-discriminatory rationale can't be our alumni favor football, so we get most donations for football, therefore we provide the most resources to football. That's not a non-discriminatory rationale, and the OCR won't recognize that. Important distinctions to understand. Moving on to sexual misconducts, and here we're in a different area of Title IX. So we leave the equity area and we go into sexual harassment, sexual misconduct area, which has been what I would say probably the primary focus for OCR over at least the last 10 years. And there have been changes in the regulations. And so what is reflected in this slide are changes that were made in 2020 which will then be changed again, unfortunately. There's currently movement to reevaluate those regulations, but let's talk about where we're at right now for your sake, because the regulations are currently in place. They haven't been changed yet. And those regulations first revised the definition of the types of sexual misconduct covered by Title IX rules. I'm going to talk about that here in a second. It added an emphasis on equal right of parties. So what the concern was from the last administration and the education department in particular is that there were an overemphasis on victims' rights and not sufficient due process provided to those that were accused in these situations. So there's a presumption now that a respondent did not violate the policy unless there's a determination made at hearing. Live hearing includes cross-examination, relevance rulings of information, and you can include expert witnesses. And there's revised procedural parameters that include triggers for institutional responsibility, notice requirements, appeals, and informal resolution. So the current regulations went into effect August 14th, 2020. They don't apply to anything that occurred prior to that effective date, which would be assessed according to the guidance and regulations in place at the time of something that occurred prior to August 14th, 2020. But the current definition in those regulations of sexual harassment is unwelcome conduct that a reasonable person would consider so severe and pervasive and objectively offensive that it effectively denies a person of equal access to an education program or activity. So the attempt here was to narrow those situations where Title IX harassment would rise to the level of an investigation and full-on review at an institutional level. And one way to do that was to create some reasonable person analysis that must be done by the institution itself, and an analysis of what triggers some sort of offensive conduct related to sexual harassment. So let's say a complaint is filed under the new regulations. There are ways that a formal complaint must be dismissed. And that's if it's filed by a victim and the alleged victim is not a current participant in an education program. So that individual has a problem, files a complaint, withdraws from class. That is a reason to dismiss a formal complaint. And when I'm talking about these complaints, I'm talking about complaints that are made through the institution's Title IX process, not outside in a judicial capacity or complaint that's levied with the OCR. Complaint that does not allege sexual harassment in the institution's educational programs. So something occurs that's not within the program itself, it's outside of the scope of the institution's jurisdiction, so to speak. That is a complaint must be dismissed. So an example of that would be sexual harassment that occurs outside abroad in a study program abroad. Conduct that would not amount to sexual harassment, even if it occurred as reported. So there's a preliminary determination that could be made that the conduct that's alleged doesn't meet that severe and pervasive standard, such that the formal complaint would be summarily dismissed. And allegations may still be addressed under institutional policy. So just because something isn't quote unquote a Title IX violation or not determined to be fall under that policy, that doesn't mean that there's not another harassment policy or bullying policy at your institution where the conduct that's being reported could be applied in a student conduct situation. So that's another thing to take note of, that just because something doesn't rise to the level of a formal Title IX complaint doesn't mean that it shouldn't be evaluated seriously under other institutional policies. When may we dismiss a formal complaint? If there's the alleged victim indicates in writing to withdraw the complaint, the respondent is no longer enrolled or employed at the institution. So this happens fairly regularly, where student athlete has a pending Title IX claim, leaves the institution. that individual is no longer under that institutional jurisdiction, and that Title IX claim, goes uninvestigated at that point. So Title IX in the context of institutions, really about protecting the institutional community from unwanted sexual harassment. Now, there has been a movement at the NCAA level to require institutions to seek guidance when an individual transfers from another 2 or 4 year school to determine if they had a pending claim prior to arriving at the institution. Some institutions' applications will request information about pending disciplinary actions, but not all of them. And there have been situations where individuals, highly publicized situations, where individuals have transferred schools with the pending Title IX claim or an issue involving campus violence, and gone to another institution and committed a heinous act, that they were allegedly committed a heinous act at that institution. And in those situations, the institution and the former institution sometimes point fingers at each other about who's responsible for providing that information. There is a Ferpa exception, and we're going to talk about Ferpa here in a minute, but that allows for institutions to provide information related to their disciplinary process when requested for application purposes. So there isn't the ability for institutions to provide that information separate and apart from seeking a waiver from the individual student athlete to produce an educational record. So like I mentioned, whenever we're talking about Title IX and student athletes and students, we have to talk about FERPA, which has some privacy requirements. And under the Act, a student does have the right to review their own education records. They can seek to amend those records, and they can limit the disclosure of those of the information in those records. However, as I mentioned, there are exceptions for disciplinary actions that are taken that allows institution to institution communication. So, for example, a student athlete, can't seal his Title IX record and prevent an institution from disclosing it if it's requested. But in any of these situations, we need to be cognizant of confidentiality and FERPA's role in that. Sexual harassment cases obviously should be treated as confidential by the institution, and information should only be shared as necessary to ensure the policies being effectuated. Records containing or identifying information on students are subject to the FERPA analysis, so we always have to be cognizant of that whenever there is information that's being shared, both internally within the institution related to an investigation, or if the investigation involves outside parties, and then potentially externally. Title IX regulation contains a preemption permitting FERPA protected material to be used as required by Title IX itself. So within the process itself, on your institution's campus, all information can be used to determine whether there's a Title IX violation that has occurred consistent with the university's policies. This is something that comes up in the context of student-to-student issues pretty regularly. Title IX regulations prohibit an institution from restricting the abilities of parties to discuss the allegations under investigation or to gather and present evidence. That makes it, so institutions oftentimes ask for confidentiality, but this would allow for, there to be ongoing communication between students in respect to Title IX matters. And the concern is, witness manipulation or intimidation. And so that issue, though, separate and apart from the ability to generally talk about it, can still be addressed through another institutional policy that prohibits, harassment of an individual who makes a claim. And that's typically how institutions do it currently within their own policies to prohibit those types of actions. So just, wrapping up here, and then I'll take questions, some practical advice. I think that in the context of esports in particular, there at least is some information out there that there, when it comes to the harassment prong of Title IX, that there's significant concerns related to the gameplay itself. And I just, found a 2019 survey from the Anti-Defamation League found that 65% of players reported experiencing severe harassment, including physical threats, sustained harassing, and stalking. And exposure to such behavior, the study shows, found that 23% of players became less social, and 1 in 10 players said they had suicidal thoughts after being harassed while playing online. And some of that harassment certainly rises, at least anecdotally, as it's been presented, rises to the level of a Title IX complaint that should be made and then evaluated by the institution. But don't do it yourself. There's a Title IX coordinator on every campus. That's a requirement. And so I think that in consultation with Title IX coordinator, you need to determine if there is a particular report that's made, whether it rises to the level of something that needs to be evaluated by that office. And then the other question is, do we have other policies that address issues of conduct that would be implicated if there is harassing behavior or something related to harassment that has occurred, and how are those implemented? If we don't have any of those policies, should we have any policies? For example, should you be able to suspend an athlete pending an outcome of any type of investigation? Many institutions have some sort of policy that allows for discretion within their programs. Athletics in particular, and esports and any sort of extracurricular activity is discretionary, and typically there's been a lot of deference given to institutions to allow or not allow participation in those activities. And so there is the ability to draw some clear lines in the sand, should you so choose as an institution, both in respects to items that are clearly within Title IX as harassing, but also other activities that might be just deemed to be bullying, or just inconsistent with an institution's values in terms of gameplay and how that's going to occur. What's next for Title IX? Some more changes. Unfortunately, policies regulations we just got used to and institutions have adopted. They've now published amendments to those policies. Anytime there's a change in administration, there may be a change in how the OCR views things and enforces things. I think there's going to be a shift back to a focus on victim advocacy versus due process concerns. And but the important thing right now is the amendments that I discussed, and the current status remains in place as the Department of Education determines what new rules may be applied in the Title IX area. I would just note that our firm regularly provides educational opportunities, both Title IX and other areas of higher education, that if you're interested in, you can find us online and sign up for legal alerts and webinars that are offered free of charge. With that, I will take any questions that anyone has.
Okay, I'm going to pull up the chat here. So if you guys are joining us virtually, feel free to drop some questions in the Zoom chat. If you are here physically and want to ask questions, I have the mic. Do we have any to start off? Oh, I got one in the audience. Let me go hand her the mic.
Great.
Hi, Tiffany Ford, Ozarks Technical. So I realize this might be a difficult question given what you originally said about how Title IX may or may not apply to esports. But I realize in traditional athletics, we often look at sports as being gendered. So you have a women's sport, you have a men's sport, but in esports, it's not run that way, and teams are mixed genders. So when we are looking at questions of equity, should we be looking at as like a whole program, or should I be thinking of that as a more granular team-based game-based issue?
Yeah. Well, it's a good question. I guess first I would suggest that you work with your Title IX office, and in particular, those that there's an Equity in Athletics Disclosure Act. So each institution has to annually report its equity that in athletics, and typically that's done through traditional intercollegiate sports. I would imagine that esports has not been a consideration for that. And so if it's not a consideration, then you're not subject to the equity requirements. I will say, just as a general practice, it makes sense to determine either whatever makes the most sense for purposes of your programs, but to have some sort of understanding as to whether we need to increase male versus female participation and how we can do that organically versus getting into a numbers game at this point in particular. So I would recommend first going to your Title IX office, asking about the Equity in Athletics Disclosure Act, and then talking about your program in particular. I think that probably as of today, most institutions are not considering esports to be part of something that's disclosed or subject to Equity in Athletics Act. I think that could change pretty significantly over time. And so being proactive on how you are handling that within your program, and documenting why there is a discrepancy, if there is, because of gameplay and so forth, would be a valuable exercise.
Thank you.
Yeah.
Oh, I got another question from the audience.
This might sound like a stupid question, but I know there's no stupid questions, but the equity aspect you had mentioned programs that are under the athletic department. Our program is under academic affairs. And so does the equity in athletics apply to programs that are under academic affairs?
Yeah. It's a good question, because there are various ways that departments structure this. The answer is typically no. They have not traditionally applied the analysis. I think that could change over time, depending on, again, the emphasis and whether there are any complaints levied related to equity issues at a particular institution that addresses esports. So sometimes we're only as good as the enforcement mechanisms that the department uses in terms of us understanding how this rule really applies. But I would say, generally speaking, if it's not part of intercollegiate athletics, it typically, so club sports would be the example, have not been considered for purposes of the equity analysis.
All right, any other questions from the audience? Okay, do we have any on Zoom? Nope. Okay. We still have a couple minutes left. I'll leave it open in case there's folks that are still kind of typing in the Zoom chat. Jason, what would be, if somebody, besides like the QR code that you had thrown up on the slide, what would be a good opportunity for folks to be able to reach out to you and connect to you if they had additional questions?
Yeah, sure. No, I appreciate that. You can always just email me directly, and I'll work. If I don't know the answer, one of my colleagues who used to work at OCR or work with me in higher education likely has the answer. It's jason.montgomery, Montgomery at Husch, HUSCH, Blackwell.com. You can just send me an email, and be happy to respond with an answer, or at least any sort of guidance I can provide.
Awesome. Anytime for last minute questions while you guys have the opportunity. Going once, twice, sold. All right. Well, thank you, Jason, for coming to speak with us today. I know Title IX's always been something that our membership has always been very curious about, and essentially how it impacts their program. So thank you for sharing your knowledge and expertise. And again, if you guys have further follow-up questions, Jason would be an excellent resource. But thank you, Jason, for joining us. And thank you guys for joining in on the conversation as well.
Yeah, my pleasure. Thanks for having me. It's a really interesting area, probably going to continue to develop. And as things come out, I will communicate with Michael and NACE any legal developments that I'm aware of, so he can get it to the membership.
Awesome. All right. Well, thank you guys. Thank you, everyone. Enjoy the next panel. You've got some time.